I'd like to call this meeting of the Westminster, City of Westminster Board of Zoning Appeals meeting. I'd like to call it to order. It's August 1st, 2023. And I'd like to begin with some introductions for the record from everybody who's on the call. Again, I'm Larry Barrent. I'm chairman of the board.
I'm Brenda Fraser. I'm board member. Oh, sorry, Leanne.
No, that's okay. It's excellent. Thanks, Brenda.
Scott Graff, board member.
And vice chair, as I recall.
Karen Ruff, board attorney.
You can
Mark Depot, the Director of Community Planning and Development for the city.
Leanne Champney, Comprehensive Planner for the City of Westminster.
Okay, we have the agenda here. Moving on, we have minutes from two previous hearings. One was June 6th of this year, and the other one was July 11th of this year. Board members, you received copies of these meeting summaries. Have you had a chance to review them? If so, can I have a motion to we'll do one at a time, accept the June 6th, 2023 minutes and summaries of the meeting?
I move to accept the minutes of the June 6, 2023 meeting.
Second?
Second.
All in favor? Aye.
Aye.
Aye. Okay, and we also have the minutes of July 11th, 2023. I'm going to assume that all members have reviewed these. Can I have, I'll make a motion to accept these minutes into the record. Is there a second?
Second.
All in favor? Aye.
Aye.
Okay. We have no hearing tonight. We have a couple of decisions to review and approve. Just one point for you, Leanne, if you can in future agendas list them by case number and title. So,
Okay.
so they're on the record.
Yeah,
Okay.
that's okay.
Yeah, thank you. Appreciate it. I have the minutes, or I'm sorry, the decision in order of case 2301. Applicant is Len Stoller, Inc. and Five Amigos LLC. It's a decision in order approving a special exception for the freestanding car wash at Len Stoller Chevrolet located at 900 Baltimore Boulevard, Westminster, Maryland. Do I hear a motion to accept this decision?
I make a motion to accept.
I'll second. All in favor? Aye. Okay. Okay, we have another decision. It's case 2302. It's St. Michael on behalf of heirs of the dog, excuse me, and Local Lane Center LLC. This is a decision in order of the board to approving a special exception for a brewery and tasting room located at 41 East Main Street, Westminster, Maryland. Any questions from board members? If not, to hear a motion to approve?
I'll make the motion.
I'll second. All in favor? Aye.
Aye.
Aye. Okay, it's unanimous. So I guess now our other business of the evening is it's a continuation of our discussion on the proposed general procedures and legal, actually that's the rules of order and procedure for the Board of Zoning Appeals of Westminster. That's the official name of the document. It has been discussed, amended, discussed and amended again, and we're hoping to finalize, if the board so approves, the final draft of these rules of order and procedure. So I'm going to turn it over to our counsel, Karen Ruff. She's kindly written and amended these procedures and knows them probably better than anybody, and she's also our legal counsel. So I'll just turn it over to you to lead the discussion at this point.
So since we last met, I revised the rules of procedure and circulated them to everybody so that they could see what was before you tonight. Since then, there have been two suggested revisions by staff. One of them is on page 1 of 8. It is section 2B1. We had that the pre-hearing statement must include the following information, and number 1 was a statement of the grounds upon which the appeal or petition is based. Mr. Depot asked that we also add including addressing applicable city code section 164, 161A3, or section 164, 169, and 164, 170. So is the board amenable to that change?
Can you give us a quick summary of what these include, these sections?
Those are the sections that you see set forth in the staff report that contain the criteria for approval for either a variance or a special exception.
Okay,
And the A3 is the reference to the variance, and 169 is the reference to the special exception. And I'm sure Mark will correct me if I misstated that.
okay, variance, it's showing on the on that page, code section 164-161A3. Is that correct?
Yes.
Yep, okay. I thought I heard a different number. That's okay.
161A3 and then 169 and 170.
Okay, that doesn't appear on my copy. Is that, Mark, are you suggesting that be included as part of that?
Yeah, it essentially provides a clarity when somebody submits an application, when we're asking for them to provide testimony and information on the grounds supporting whether it's a variance or a special exception. We're asking, for an example, 164, 161A, 3A are the findings that the board must find to authorize a variance. So
Right.
we're asking they demonstrate that there are exceptional, extraordinary circumstances, that they provide
Right.
information that such variance is necessary, and so forth, so on and so forth. It just kind of gearing them or directing them to what information is needed. And then obviously the special exception standards that run of listed items, as well as the elements that the board must find to approve the special exception as well. So again, just guiding them to the information we think you would need for them to demonstrate when they are the ones who are required that have the burden of proof in these cases.
Okay, so I guess, Karen, I guess if you would read the subsection, I guess we need a vote by the board on this amendment. If you would read it into the record for us.
So what it says is on page 1 of 8 in section 2B1, it would be in addition to a statement of the grounds upon which the appeal or petition is based, and we'd be adding, including addressing applicable city code, section 164-161A3, or section 164-169, and section 164-170. And as Mr. Depot noted, the first section refers to variances. 169 is the criteria for determination. And the board is asked to look at that when they consider testimony submitted for or against any appeal or petition. And then 170 is the conditions for grant of a special exception. So it's really just directing, as Mr. Depot said, directing them to the right sections of the city code that they have to address in the pre-hearing statement, and which the board is going to want to hear about at the hearing, because as it was already stated, they have the burden of proof. I think it's a great addition. I would recommend it.
Brenda and Scott, do you have any questions, suggestions, comments on this particular amendment?
No,
I
I'm
have-
fine with adding that in. We already look at it, so we might as well put it in the policies and procedures.
I have no objection either.
Oh, okay. Nor do I. So do I have a motion to accept the amendment of this provision as outlined by counsel for the board? Anybody?
I'll make a motion to approve.
Thank you.
I'll second.
Okay, all in favor, say aye. Aye. Okay, so this amendment to the proposed rules of procedure has been accepted by the board. Karen?
Okay, and then the next section that's in question is section 8.4. And that's at the bottom of page 3. And what had been proposed is that the staff of the Department of Community Planning and Development distribute all pertinent information relating to agenda items for each BZA meeting to the BZA at least 7 calendar days prior to a scheduled meeting, a copy of which shall be provided to the applicant and posted on the town's website. Mr. Depot has asked that we delete the reference to staff being the one to distribute it, so that the sentence would then begin with all. So it'd be all pertinent information. And then he wanted to say provided by the applicant or petitioner relating to acceptable agenda items for each BZA meeting will be distributed to the BZA at least 20 calendar days prior to a scheduled meeting, and then delete the obligation to provide it to the applicant. And I will let him address that, but I believe that that's because if he's giving us information that the applicant or petitioner has submitted, there's really no reason to provide a copy of that to the applicant. The 20 days ties into the advertising requirement in section 164, 166B. Now changing that from 7 to 20 days, I think also addresses another issue that the board has mentioned, and that is wanting to know whether or not there's going to be a meeting of a particular in a particular month. This way you would have the information at the time that it is advertised. So I'd like to focus on that one sentence before we go on to the other revisions in that paragraph. And I'd like to ask Mr. Depot if he would like to add anything to what I've said, so that they have a full understanding of that proposal before they discuss it.
I think
Okay, we're doing the first, dealing with only the first sentence of the proposed 8.4.
Correct.
Okay. I just dropped a pen.
I think something we've never had a discussion about is how applications are submitted and how they're processed. And I think that you don't get to see any of that. You just get staff reports, whatever it may be, when we send it out to you. So previously, when an application would be submitted, we would just get an application, no information provided typically. And then once that 15 days prior to the meeting came about, which would be after we've already advertised for the hearing, whether it's a variance or special exception, we get more information. Giving us 15 days to digest that and try to work out a staff report. In several cases, we're working on up till Friday with an applicant, trying to get things from them to put together in the packet and to answer questions we're going to have for the staff report. So now what we're saying, or what the board is proposing, is that that information be provided in the front end of submissions. So that then allows us to determine whether an application is sufficient if they've met the requirements for submission. Past, it was just an application. There was nothing that said what they had to submit. They just submitted the application for variance, minimal information, or for a special exception. Now that we're getting that front end information, we then have this ability to say, yes, and I'm not talking about what they're saying. We're not challenging their argument for a variance or special exception, just that they have addressed those sections and provided the information necessary. And once it's determined it's acceptable, we can then start scheduling when it would be for the next Board of Zoning Appeals. And once we do that, we backtrack the time from every subsequent meeting to figure out when applications need to be advertised. We actually have a full table that it wouldn't hurt to actually get this to the Board of Zoning Appeals, actually. That we follow, knowing when an application has to be advertised for that 20 days. Once we know it's to be advertised, and Larry, I think this is what some of the misconception was. You weren't provided staff reports early. What Andrew did, which I found out, was providing you the application, the pre-hearing statements once they came in. In all honesty, I wasn't sure he was doing that. And he'd actually place it online too. So the Board of Zoning Appeals was getting that application information initially. So in this case, once we know it's going to be advertised, we know it's coming, and the day it gets advertised, 20 days, we then would send it to Board of Zoning Appeals members as well. So now you know it's been advertised, this application is coming before you, the next meeting. And we will also place it on the webpage, the application, as well as all the documentation that goes with that application. And that's what we used to do in the past. And because there is something in the actual city code that references that applications shall be provided to the board. And I guess Angie took that to mean that applications, once submitted and handed to us, immediately got in the hands of the Board of Zoning Appeals. I'm not used to doing it that way. So, but now with the way that the BZA is looking at it, we'll be able to get all this information, the application, the data information provided from the applicant to you 20 days in advance. So you will get that packet of what they're proposing, which then allows you the ability to go out on site or do what you might want to do, or as you're proceeding through. So that's what we're trying to say here. That's the 20 days versus 7 days. It fits with, again, advertising. You're then made aware that this is coming. So again, addressing another BZA issue. Now, as far as staff and DCP, I've already made my statements there. There's nothing in the state code or city code that authorizes the Board of Zoning Appeals to direct a city agency to act. Only the mayor and common council and the city administrator are able to do that.
That's not what we're saying, though.
You're saying staff shall distribute all pertinent, that's directing me to perform a duty. You do not have that authority. Neither the state nor the city code allows for that. And that's my concern. And these are rules of procedure for the Board of Zoning Appeals. These are not DCPD or Department of Community Planning rules. And ultimately, your rules are to govern your transaction of your business and conduct your meetings efficiently. They're not to authorize or direct staff to do something. And we're not employees of the BZA.
Well, here's my problem. I've done a little digging here, but state law requires when you're talking about Board of Appeals, I'm looking at the Maryland Code and annotated of the land use article, section 4.306. If I go back to 4.304, it says a Board of Appeals shall adopt rules in accordance with any local law adopted under this division, which is kind of what you're saying. But it says the board, in our code says the board also is empowered to adopt and promulgate such rules and regulations that shall be deemed necessary to perform its responsibilities, including the conduct of the hearings and the issuance of decision. We're not in any way saying that we're directing the, your department or any department to, I guess, go do something that you're not supposed to be doing as a department. But under section 4-306, when it says to the record, it says who may file, timing, and the record. It says the administrative officer, a unit from whose action the appeal is taken, shall transmit promptly to the board all papers constituting the record of the action appeal. That's what we're looking for. We're not giving us the information like 1.5 business days before the hearing has always been unacceptable. It seems to be something that you don't have a problem with. And that's where we're butting heads. We're not saying we're that you're being ordered to do something. What we're saying is we're supposed to be working, for the benefit of the city and trying to work the best we can together. And certainly the fact that the board and applicants were getting information business day and a half before the hearing was unacceptable. If we can come around to an understanding, which the 20 days certainly I think does make a whole lot of sense. It certainly gets the ball rolling in terms of the information we're being able to digest, for the particular applications. So if we can work out something, along those lines, I don't have any problem with it. But and nobody's saying that we're trying to order you to do things. But
That's what the statement states. Staff of the Department of Community Planning Development shall. That is, you are directing me to do something, my department to do something. I don't think the state authorizes you. It authorizes you how to perform your duties.
I don't have any
not to perform or
problem.
require
I don't
by-
have any problem with saying, like as we said at the end of the third page, using their best efforts. That is not directing you to do anything. It's just basically requesting you do your job, to do the best efforts to get the information that we need. So if I'm happy to say use your best efforts, and if it turns out there's a consistent where it isn't using your best efforts, then maybe we can complain. We're not ordering, we'd have to go up the food chain, obviously, to complain. But what we need is the information as soon as we can. And the applicants and the people and the public needs the information. If you use your best efforts, I don't have any problem with that. This is just my personal opinion, but I don't see a day and a half, business days before a hearing to be able to digest it and respond and et cetera is your best. If it's your best efforts, let me know.
So may I ask a question? So as was stated, the Board of Zoning Appeals is a board of the City of Westminster. And Mr. Depot, your office is the liaison basically to the board. And it's always been that way. So nobody, I don't think, is trying to task you with additional things. It's more that your office has always been the one who has staffed the board and has been the one to prepare it, which is why it says you're the ones that do that. You're the ones that receive the applications. You're the ones that.
But with
do
all due
the
respect, that's
public-
not what it's saying. I'm the director. I direct my staff when reports are due, and I control my work plan. That is my job, my responsibility as laid out by the mayor and common council and the city administrator. I determine the duties that my staff does. The mayor and common council and the city administrator determine what my duties are to perform. So again, it's the naming of my department as shall I can't see how that is relevant. And if I don't, because I'm not subject to this rule, these rules are like regulations, not mine. These are the Board of Zoning Appeals. I have my own procedures and policies that I have, which I'd be more than happy to share with you and alter as I see fit. But this is stating that I shall do something, and they do not, BZA does not have that authority.
So you're saying
Again,
at the end of this paragraph, a copy of the staff report shall also be provided to the applicant and posted on the town website.
But there's no requirement for a staff report. I'm not required. There's nothing in the state code or the city code that requires a staff report. It just says the applications and information provided by the applicant must get to the BZA. If that's a policy that we've decided to do is do staff reports, that's up to us. We're not subject to that. The state code doesn't require it, nor does the city code. So again,
We're not saying that.
it says, in addition, DCPD staff shall prepare a written staff report containing a recommendation. You are directing us not only to do a staff report, but also provide recommendations. And again, I don't think you have that authority to direct.
But
So
have
you're
you
saying
historically-
that. I'm sorry, go ahead.
No, again, it's
You-
not a shall statement. It's,
but-
but the other jurisdictions throughout the state, some don't even do staff reports. They just provide the application and the burden of proof by the applicant, and it's up to the BZA to determine whether they meet it or not. There is no staff report. Other places have hearing examiners, where it is more like a courtroom, but there's nothing in this, nothing that states that we are subject to that. And again, I have no problem sharing you with what we do, and I do plan to do staff reports. I just don't see how the BZA has the authority in their rules of procedure that govern them to tell my department and me what I do. This is not under the purview of the BZA or in my department that I'm subject to these rules of procedure. So to make the statement, if I miss a day, if we miss something, then what happens with the rules? I just don't see how it's legal anywhere that this statement would be allowed. And I'm subject to.
Well, I'm gonna step back here and just let either Scott and Brenda, if you have questions. Anybody?
The only thing I had said in the previous email was that, I mean, the first time I reviewed a case with the city was for one of the properties out, I think, in Tech Court. And yeah, the staff reports are pretty substantial in nature. And you know, if it was a timing issue, or if it was something that's just burdensome for staff to have to, you know, crank those out every time we have a case, then you know, we could look into sort of paring down and abridging those to a more manageable level. And it sounds like Mark intends to do them. It sounds like that's not an issue, whether they're going to do them or not. It's just a matter of when it has to get to us, or basically putting a deadline on them to get it to us.
The only thing, go ahead.
No, go ahead.
No, the big thing for me, and I think Mark, this may address it, but my thing was we weren't getting anything until the day. This whole 20 days will be a game changer, I think, for me, to be able to, because I don't think that we were getting anything prior to, sometimes the day before, day of, and didn't even know if we were having that hearing. So as long as that piece of it comes and the staff report, I'm not so worried about that coming so far, but I do think it's important to start giving us the applications, because sometimes if you send an application and I'm not familiar with the area, in my spare time, I might get in my car and drive to the area and kind of take a peek at it. If I don't get it till the day before, or even the weekend before, this Friday, that makes that piece of that impossible sometimes. So I think it's important to understand that 20 days is a game changer. So if you send us everything that the applicant is and needs to apply prior to the staff report, then I'm okay with that piece of it. unless I missed something, because I don't have it in front of me. I'm just listening, and when you start saying all these numbers and I don't have it in front of me. But Karen, you can let me know if I'm misinterpreting what I'm hearing, but that's kind of where I am on it.
Yeah, I
And-
think I think a staff report and the application and exhibits to the application, all that, if we only have a day or two to digest that, that is a bit much. Again, I've only been in two
And
cycles.
I agree. And I agree. Had I known that that was being provided prior to, we would have started working on that now. And because Larry, you said you kept getting staff reports. So I started researching what did we do in the past? Because I know staff reports always still came out on the Friday, but you were given a lot of information prior to that. Certainly helps the Board of Zoning Appeals to understand the case.
But we're not
But-
getting it now.
But we will
This
be.
will correct it. This will
Yes,
correct
well,
it. You're right.
Again, and I'm fine with the first, I'm just asking that staff of the Department of Community Planning shall distribute. I think that should be struck. I'm fine at saying all pertinent information related to agenda items for each BZA meeting,
But
to
isn't
the-
that your job?
at least 20 days.
Yeah.
No, it's,
Are you saying, okay, if the first sentence there, if it's said, if you're saying the only change you're making is from 7 days to at least 20 days, right?
and removing the shall directing my staff. Again, you're right. It's the liaison that's responsible. I just don't think it's appropriate that you have that shall statement. If by saying all pertinent information related to the
How would
agenda
you
items-
change it?
I would, that's what I would get, I would remove staff of the Department of Community Plan Development shall distribute.
Well, who's gonna give us the information? Is it gonna come from, the tooth fairy?
But all this information, no, again, it just says all pertinent information. It would be the liaison, and that's just common, but I
Who's the
don't think it's,
liaison?
I would be the liaison.
And you're the Department of Planning Department. I mean, you got circular reasoning here, Mark.
No, it's
If it's 20,
the-
if it's 20 days in advance, that's fine. The question is, how do we get it? How is there a responsibility? Where do we put the responsibility of the board saying, hey, we're not getting things in 20 days, so we need to go to somebody. If you're saying you're the person to deliver, but you don't want to admit to it in the rules, is essentially what you're saying.
I think it says
No.
earlier on in the document that they are the recipients of the application. It's one of the first things that was in here is that the application shall come in to Mark's department. And so,
Yeah, so I don't understand why he's reluctant to state the obvious.
because one, I just don't think it's appropriate. I think it's already stated. I think knowing that we are the ones who collect it, and the statement just starts off saying all pertinent information related to agenda items for each BZA meeting. I'm just not comfortable with that initial statement of shall and directing staff. Essentially, you're right. In a roundabout way it is, but I'm not uncomfortable that the
All right,
rules of
how about,
procedure
how
for the
about this?
BZA.
How about all pertinent information related to the agenda items for each BZA meeting shall be distributed to at least 20 calendar days in advance.
I'm fine with that. Again, I think it's saying the same thing. I agree with you. I just am uncomfortable with the absolute statement of shall. Obviously, we're going to work towards that. If it doesn't get to you in 20 days prior to the meeting, I don't like how that may affect the entire process itself. But I'm okay.
I think you're overstating the problem here. I'm sure there are plenty of rules of other departments and other boards where if you miss a day or so, you don't go to the next hearing date, which is what you were implying in one of your earlier statements in another hearing. What we're trying to do is work to the same conclusion here. So let me again say, and Karen, help me here so that you got the right information. If you're uncomfortable with that, your department shall distribute all pertinent information. I would propose that all pertinent information relating to the agenda items for each BZA meeting be distributed to the BZA at least 20 calendar days in advance. Does that work?
It
Yes.
works with respect to what they may have in hand at that 20-day mark, right?
Yeah.
So, and I think that's why Mr. Depot suggested that it say all pertinent information provided by the applicant or the petitioner. I don't know that you need to have that. Because I think if you,
If they don't have a complete application,
right,
then
whatever,
it's, you can't accept it and you can't move forward. So they got to wait till the next month.
right,
And the only reason I added petitioner, applicant or petitioner, not, so again, it's for if public's viewing this, that everybody knows that's the information that's being provided in 20 days. There is no staff information, or anything else being provided. It's just more clarifying language that this is what's expected 20 days in advance is the information provided by the applicant or petitioner.
so if we're good on that sentence, when you go to the next one, because it kind of ties into what we're talking about. All pertinent information provided by persons or entities in opposition to an application will be distributed to the BZA at least 5 calendar days prior to a scheduled meeting and posted on the town's website or city's website. I'm sorry, I don't know why it says town.
Did I suggest that?
No, that's what was in there. Mark's questioning whether that's necessary. We could say that all such information provided by opposition be submitted along with the staff report.
No, I think I was just trying to make sure that there wasn't a conflict, because as Brenda pointed out too, there's a lot of dates in here. When somebody in opposition has to provide information. I just want to, I think I was highlighting that whether it's needed or if it's referenced elsewhere, or is the 5 days accurate from everything? I just don't want to make, I want to try to have consistency and because I think opposition has to submit things no later than 7 days prior to the date of the hearing.
I'll just interject. That is it's in the actual code relating to the Board of Zoning Appeals as the opposition, and it says 7 days, but then it also says that they can also appear on the night of the hearing as well.
Right.
So it's just making sure that we don't end up going slightly against the code in creating a 5-day deadline. Just
Well, I
So
don't
I-
think it goes against the code because you would have it at least 7 days, so you would have it to distribute. But I guess my question to the board would be, rather than having staff have to give that information separate and apart from the staff report, if the staff report's not ready at the time, would it be better to just have the whatever they've received in opposition submitted to the board with the staff report?
I think that will work for me. I don't know about the other board members.
I think that's fine, as long as what Leanne said, holds true, that doesn't preclude anybody from submitting anything the night of the hearing as far as opposition.
Yeah.
Yeah, no, it doesn't, and you're, there's another rule, and if I was fast enough. to
It's
find it-
section 8.1 that says the exact same thing.
Yeah.
That's 7 days prior to, and then nothing in this section should be construed to limit the rights of individual members of the public to submit testimony during the hearing.
So this
What
is
is-
just saying what you have, you'll distribute. It's not.
Yeah.
Saying anything more than that in this section.
I mean, I do like, I don't know how you want to do it in a policy. I mean, truthfully, if somebody sent an opposition, if you have it and you can forward it along, I don't know how you put this in a document. It would be great and could be helpful. Again, maybe we want to take a ride by and see that opposition's theory or whatever. So if you get it, it would be great. So I don't know if we put it in there. If you get it, it'd be great. Maybe that's the official term, but that's helpful. If possible, if whatever, to include that, to forward to the BZA if there is opposition for review prior to the night of. That's helpful.
Okay.
And I think that because this becomes, and Larry, this is exactly what I'm trying to point out, which makes it difficult on staff. So 7 days that we get opposition, we may get it near the end of the day. or when we're not even there, they still meet the 7-day. So we get it to you we can send that directly to the BZA once we have it. This is opposition for this case. We can actually put it up on the webpage too in that day. But then it goes back to us to amend our staff report to make reference to the opposition and to provide information regarding to that. So you see, it's not easy to just state a staff report is due at a certain time. That's the point I'm constantly trying to make. It's constantly moving with information being provided, which makes that job very difficult.
Can I ask a question about the opposition? You just said something, Mark, I didn't realize. When you get it 7 days ahead of time, are you required to post it when you get it, or is that, I don't know. That's a question.
I just think it's similar to getting the information that we're providing the time of for the applicant. I just think it's fair that if opposition provides information, that we get it up for the public to see as quick as possible. Because
Okay,
again,
so is there any way that that's just part of the process then? Like if something's posted, it also gets forwarded?
yeah, and that's what we're doing. So just like for the 20 days, once we send
Right.
it, we'll put the out. We have to get the advertisement out. Then we'll send it to you first. And once it's emailed out to the BZA members, we would then post it at the end of the day, that end of that 20-day prior to the meeting on the webpage.
Right.
Because again, it's all fairness too. So if anybody is interested in tracking it, they have as much time as you do to read it over and then provide any information in opposition they may have. Because I don't think we don't post it until 15 days prior to.
Which
I think it's
would be-
14.
it's
14.
it's 14 days to be posted on the site, and 14 days for neighbors as well to be informed.
Now, again, I think a lot of that, and this becomes more of an internal thing, with the ability of getting information up front, like you guys are doing, which I think is awesome, because again, it really does help us out. Because a lot of times we're still working with them and preparing and making sure we're getting the information we need. I think it also gives us time to start preparing for the sign to be put out, the advertisement to be done. I can't see why, even though the code says by a certain time, I can't see why equally in that 20 days, we couldn't work to get the sign out prior to the 14. I mean, obviously, we know it has to be by 14 days, but again, with front loading everything, the information we getting it really allows us to manage applications and what we do internally. So everything I was talking about, we have this form that shows every month and what you have to do. That's going to change because of this getting this information up front. So that I'm sorry, I'm kind of went a little too long there, but you can see that really does help us out. So I think that will help out the BZA as well. So that's it.
Yeah, I would just say, looking forward here, I think some of the, the changes we're making here, I'm comfortable with. Some of the language, is, it maybe was, I won't say being misunderstood, but maybe not focused right, and it might be partly, by me as the chairman, and maybe partly by other people. But I think what we're doing with this particular paragraph, particularly the 20 days, getting the initial information, helps the board considerably in the way we do business.
Okay, great. So we have consensus on the first two sentences. And the last sentence that there's a question about, can we move on to that?
Did we need a motion to make that change or just consensus?
That's you're talking about the sentence, a copy of the staff report shall.
Right
Is that
now,
what you?
as you've been talking, I'm writing a paragraph that I will then send you, and you can take a look at it. And if you agree to it, that's what we'll insert. Okay.
Okay.
It's got the changes to those two sentences. And then the last sentence said, in addition, DCPD staff shall prepare a written staff report containing a recommendation as to each matter before the BZA and use their best efforts to distribute the staff report to the BZA at least 5 calendar days prior to a scheduled meeting. Mr. Depot has asked that we take out the DCPD staff shall prepare a written, and it just say, upon request by the BZA executive secretary may provide a staff report as to each matter, and thereby taking out the requirement for a recommendation. So the three things about this particular change that I had asked Mr. Depot is one, this is the first we've heard of a BZA executive secretary. So I'm not sure who that is. And two, upon request kind of defeats the purpose because the board has conveyed that they want a staff report for all the matters. I don't know how that would work. I mean, would you expect, Mr. Depot, that they would get the applications and then let you know whether or not they wanted a staff report for each one? I just don't see how upon request by the BZA works with that.
I would just say, make it a standing request. I think in order for us to do our job, getting and including a recommendation of the staff using their professional expertise to guide the board to make its decisions. I think those two things are pretty important. And that was something we were getting before. The recommendations, using your professional expertise to give some guidance to the board. There are many times in the past when we were getting such recommendations, there were many times in the past where the board didn't agree with them. And I think Brenda, would attest to that, the staff may say something and we might say, well, for whatever reasons, given on the record, of course, that, that we might not accept them, but having that professional expertise, I think, is extremely helpful. Anybody?
I find it helpful as well. And I'm thinking if a staff report is going to be drafted, then it should be sent out, upon completion.
I think it helps, Mark, because if you don't do that, we're gonna prove everything.
You already do.
Pro business, baby.
Yeah, I mean, in all honesty, we stopped doing recommendations because we were down to 2 people and it was very time consuming.
I would, given what Scott knows from the county, just building on that, it might be better, you might have better use of your time to have shorter reports and redo the recommendations. Because I think they're important to how we make our decisions. I've been on the board, I think it's 9 years now, something like that. Maybe I got spoiled by having those recommendations, but they sure were helpful.
Again, I think the shifting the burden of proof to the applicant that they speak first, as suggested by Ms. Ruff, I think that also changes things, that a lot of the staff reports, we were just regurgitating essentially what the applicant was stating. I think if we remove that aspect from our staff reports, we're not restating or repeating, and we're just sticking to staff comments, that certainly saves time.
And I would completely agree with that.
So again, I'm not opposed to staff reports being provided, best efforts 5 days prior to. Again, and I know it's just terminology. I'm just opposed to the DCPD staff shall prepare.
Right, I'm going to send everyone here an email right now with language that I think captures what everybody has just been saying. And then if so, we can read it into the record, so to speak.
And well, I'm not sure how you change, I wouldn't
Yeah.
mind if it's just simple saying staff reports containing the recommendation. If it just reads what's expected, that what the BZA needs, but just not that direction statement. That's, again, I don't
Well-
mind a lot of what you're saying. It's just that I'm sorry, it does irritate me and bother. So I don't mind it saying staff reports containing a recommendation as to each matter before the BZA and use shall be distributed at least at a minimum 5 days prior to the calendar, whatever it might state. But that some statement, again, I don't mind the concept. But again, these are the rules, these are what you're expecting and what you need. I just don't like that shall statement. That's just what has been bothering me.
So I see that I missed a word, because somehow in there has to be something about who is going to do it. So if you look at what I sent you, the paragraph would be changed to read, all pertinent information provided by the applicant or petitioner relating to agenda items for each BZA meeting will be distributed to the BZA at least 20 calendar days prior to a scheduled meeting and posted on the town's website. All pertinent information provided by persons or entities in opposition to an application will be distributed to the BZA upon receipt and posted on the town's website. The BZA shall be provided with a staff report regarding each matter before the BZA containing a recommendation, and staff shall use their best efforts to distribute the staff report to the BZA at least 5 calendar days prior to a scheduled meeting. A copy of the staff report shall also be provided to the applicant and posted on the town's website. Is that
Uh,
language acceptable?
To me, it
Yes.
is, absolutely.
Yeah, count me in.
I'm in.
Mark, will you agree on something?
I know,
May-
again,
Make,
I never disagreed with the having dates and calendar days and things like that. It's just making sure they fit in there, how we process things. And again, like I said, it's really improving what you guys are doing and helping out staff tremendously. It's just this statement, the shall say, I'm sorry, it was just my own personal issue. But I like what Karen sent out. I don't know if should Leanne show that on the screen or I actually read it, so that's fine.
yeah, I've read it.
Well, Karen read it on the record, so if anybody is watching out
Mm.
there,
And so we will, if the board moves to adopt the rules of procedure as presented with the changes we've discussed tonight, the document will be revised and I can send that out tomorrow, first thing in the morning. And Leanne, you can post it.
Yep.
Can we, this is for Karen, can we make a motion that, that we can review the revised document as presented verbally or whatever at the hearing? So basically that we can take that and approve it without having to come back to a meeting.
Yes, and that's why I sent you the written, because we accepted the one change before, which was just a reference to the 3 sections. This was really the language that needed to be parsed out and
Okay.
agreed to. And I didn't want to leave it as me interpreting what you said. That's why I wrote it out and sent it to everybody. If that's acceptable, I think it's fine for you to make a motion to approve the rules of order and procedure as presented with the changes that you've discussed and approved. And then
Okay.
second and adopt it. Or
And I-
not.
I think what Larry's asking, it would be nice if we can get a final document But Larry, at the end of the day, you have to sign this. So
I understand.
we're really, so I think if Karen can send out a complete copy as addressing these changes to the BZA to confirm that is accurate, then it's really up to Larry when he can come in and sign it.
Yeah. I live in Westminster, obviously, so
Yeah.
it's not too hard. Scott, any other comments?
No, I'm fine with that change.
Okay. All right, I guess I need a motion to accept maybe I'll make a motion and everybody, Scott, Brenda, and Karen, maybe you can all help me, and Mark, of course. But a motion to accept the rules of procedure for the Board of Zoning Appeals as amended in writing at this hearing with final approval to be given by board members, through emails? Karen?
So, I hate to be difficult, but two things about your motion. I would have it be adopt and not accept, right? Because that's what you
Okay.
want to do. You want to adopt them. But second of all, I don't think, I just sent you the one change through email and everybody said they're good with that. So that I'm just going to lift it and replace the one thing. So you can verify before you sign it. I don't
Right.
think we need to circulate it to the board members again for their review and approval unless the board members feel otherwise.
Well, I like that statement of that Larry could verify the changes as discussed in this hearing, that
Yeah.
the board is authorizing Larry to essentially to verify the
Yeah.
changes
It's a good
prior
idea.
to signing.
Is that okay, Karen?
Yes, sir.
Okay. So that's my motion. Is there a second?
I'll second.
All in favor, say aye.
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 Good. My gosh, we got it done. All right. Any other just comments or discussions on the rules of procedure, even though we're just any final comments by anybody?
Just one. Well, thank you, because again, it really is helping staff by adding the burden of proof to the applicant and getting the information up front. So the applications we're seeing, we've actually told applications that we've been getting in that ultimately this is the process they're going to follow. So we've asked them for that additional information. So I guess for this first time around, we're going to see this policy, this practice put in place. I guess anything that comes up or tweaks that could be made, we can certainly talk about.
Good. Any other business before the board this evening?
Any potential cases on the horizon? Yes, staff of,
There's Leanne, I think there's a home occupation.
Yes, which will be coming in September. We've yet to receive the pre-hearing statement, but I have been keeping them updated with the general rules and procedures document that is updating, stating that they will need to provide it sooner. So we've requested that information as soon as possible. We're still yet to receive that, but currently the document still says that they need to provide it 14 days. So hopefully with the changes to this document, it might help provide some clarity to them as well. So that'll be coming up in September.
Hopefully.
Hopefully,
I mean,
yes.
I'm not opposed. I mean, if I'm hearing you correctly, and I'm the last person, but if in this situation where they're already part in the process, if they give it to us in 14, 15 days and not 20, I think we allow them to still be on the docket. That's my personal opinion.
So we're comfortable still, we'll push them for, we'll tell them September, we'll get them before the BZA. The hope is they can get us some information. And we'll continue to work with them. So we can do that.
That's my opinion. I think this is still in the works and everything was published saying 14 days. I don't think we punish them for this.
Grandfather.
Yeah.
What did you say, Scott?
The
Grandfather, right.
Grandfather. Yeah.
Last one, though.
And again, just let me repeat, and maybe I got a little grumpy and maybe Mark did, I don't know. But,
I absolutely didn't. I apologize. But again, it's,
but
I
I
felt
think
my
it,
staff was being, yeah, so I'm very protective of my staff.
well, but I think it was a good exercise. I think overall it really streamlines the process. I mean, it gets things done much better than the way we're doing that past. And Mark and Leanne, thanks for all your help, and Karen, all your hard work, and board members, of course. So, but anyway, thank you. Okay, do I have a motion to adjourn?
Motion to adjourn.
Second. I'll second. All in favor? Aye. Okay, meeting is adjourned.